have it?
I beg to move that this House do now adjourn.
The question is that this House do now adjourn. Caroline Voaden.
Thank you, Madam Deputy Speaker. 22 years ago, I became part of a club that no one wants to join, the Young Widows Club. My husband Nick died of esophageal cancer, and I was left with an 18-month-old baby and a toddler. Over the course of the next couple of years, I met dozens of young widows, including Beth, whose husband Simon had died of bowel cancer just 2 days before their beautiful baby daughter Elsa was born. Beth and I navigated this strange and unwelcome new reality together, spending time with our 3 little girls who were all too young to understand the awfulness of what had happened. But Beth was part of an even smaller, even more unlucky club than me, the one where you have to give birth alone to a baby you've longed for, while at the same time grieving for the partner you've lost and the future you will never share. And for many of those tragically unlucky women, it gets even worse. Every year in the UK, around 200 young bereaved women are drawn into a ridiculous, unnecessary and costly legal battle to have their baby's father's name registered on their birth certificate. Because incredibly, in 2025, if you are pregnant when your partner dies, but you are not married, the law says that you cannot automatically name the father on the birth certificate. If ever there was a case of adding insult to injury, this has to be it. The law seems to think that if you are legally married, there is no question that your baby would be that of anyone but your husband's. But if you had been living in a committed relationship, perhaps for years on end, the fact that you don't have a ring on your finger means the paternity of your child is in question. So having been through the unimaginable experience of losing your partner while carrying his child, then giving birth alone, you are then expected to enter into a legal process to prove that he was indeed the father, so that your child doesn't grow up with a blank space on their birth certificate. Madam Deputy Speaker, this is out of date, out of touch, and frankly, quite traumatic for all those involved. Women have described it as demeaning, insulting, and overwhelming. And the reality is that more and more couples are choosing to live together without getting married. In 2022, the number of children born outside marriage in the UK surpassed the number of babies born to parents who were married or in a civil partnership for the first time since records began in 1845, according to figures from the Office for National Statistics. It's high time the law was updated to remove this anachronistic insult to unmarried mothers. Not long after I was widowed, I became involved with a brilliant organisation called WAY, Widowed and Young. It's where I met Beth and made many other lifelong friends. WAY has been running the Blank Space campaign to try and change this out-of-date law that penalises people for not being married. I commend them on their campaigning and am proud to bring this before the Minister so that this anomaly can be addressed. The women I'm going to talk about are all members of WAY, and I thank them for sharing their stories. I'd like to tell you about Nicola. She and her partner Stuart had been through a successful IVF journey, needed because Stuart had had testicular cancer 10 years earlier. 6 weeks after a positive pregnancy test, they found out that Stuart's cancer had returned, and he died 7 months into Nicola's pregnancy, never getting the chance to meet the son he had so desperately fought for. Nicola booked an appointment with the registrar, knowing that she would be going alone, but took as much paperwork as possible to show that Stuart was the father. She had a range of hospital documents signed by him, not only proving that he was the father, but also detailing his documented wishes for their embryos if he were to die. However, the registrar explained to Nicola that because they were not married, Stuart had to be physically present to be named on the birth certificate. Her evidence didn't count, and she was sent away with a birth certificate that had a blank space where Stuart's name should have been. Nicola says, "We had made this baby together, literally and scientifically, and for him not to be recognised at all was devastating. It took a year and over £1,000 to get to court. Stuart's father went along to attend the hearing with Nicola, and it took just a few minutes for the court to discuss and approve the change and add Stuart to the birth certificate, almost as if they couldn't believe that she'd had to go through this process in the first place. With overwhelming evidence and the support of blood relatives, it was the obvious decision. To have to go through this whilst bringing up a newborn on my own and grieving was utterly humiliating and exhausting," she says. Madam Deputy Speaker, I can attest to the fact that no young widow who is learning to be a mum and grieving at the same time should ever have to fight for this, and many of them couldn't afford it even if they wanted to. Paula was 18 weeks pregnant when her partner was killed while cycling to work. Despite having his DNA and a proven 99.9% match, it took 3.5 years for her to get a birth certificate with his name on it, and the process cost nearly £3,000. Eleanor's partner Robin was killed in a road traffic accident 18 days before his baby daughter was born. She says, "If you haven't been through this situation, you may not understand how demeaning this is. It made me feel like I wasn't to be trusted, as if an unmarried woman has no rights or voice. My partner and I lived together and planned to have a child. We just weren't married. It wasn't a one-night stand, and simple council tax records would have proven that. While I shouldn't have had to prove anything beyond my word, I would have willingly provided documentation and statements from both our families to confirm our relationship. In the end, the complexity and the expense of having to fight the system proved too much for Eleanor, so her daughter's birth certificate was never changed, and the blank space remains." These examples show just how difficult and cruel this situation is, and they also show that the process can be very different depending on where you live, which court you apply to, who hears the application. Like so many other things, it can become a bit of a postcode lottery. Under UK law, a birth needs to be registered within 42 days, and if the parents are unmarried, they both have to be present to be named on the birth certificate. One parent cannot add the other. If a parent has died, then the surviving parent can amend the birth certificate at a future date to include the deceased parent's name, but to do this, first you have to apply to the family court for a declaration of parentage. This involves a form and a court fee of £365, and the court application takes 3 to 4 months to be processed. Then, at an initial court hearing, a senior family judge will consider the application. Many judges have never come across this process, and I've read stories of young widows not only having to go through the process themselves, but to explain it to judges and court administrators while doing so. There may be a second hearing some months later, and in between there will be requests for DNA, evidence and witness statements. If the court approves, it will issue a document confirming that the deceased person was the child's parent, and it then makes a declaration at a court hearing. This will then be sent to the Registrar of Births, Deaths and Marriages, and it can then take several more weeks for the re-registering of the birth can be completed. Madam Deputy Speaker, I'm sure I don't need to tell you that this is a tortuous process. One of those bits of bureaucracy that seems ridiculous when you actually spell out the whole process, as I did here. At the best of times, it would be frustrating and slow, and at the worst of times, it can simply be too much to cope with. The paperwork of death is long and frustrating and sometimes complicated. I remember being told by one organisation that they had to have written confirmation from my husband to close an account, even though I had written to them to tell them that he had died. I'd like to think things have moved on in the last 23 years, but we seem to have created a system that overcomplicates everything. And my speech has now got muddled up. Clearly, it would not be right for someone to be able to put someone else's name down on a birth certificate as the father without reasonable proof. But what Way is campaigning for is a way to resolve this issue so that women whose partners have died during pregnancy can follow a clear and simple process to register their partner on their child's birth certificate. It should not cost thousands of pounds. It should not be so complicated that some women just give up through frustration. In Switzerland, France and Germany, unmarried fathers can declare their parentage early in the pregnancy to protect their rights. We have parental responsibility agreements here for unmarried fathers, so perhaps one answer is to bring that forward into pregnancy, and then if the worst, most unimaginable tragedy happens during pregnancy, there is one less thing for newly widowed mums to have to worry about. Doctors could make a record of who the father is when the pregnancy is first entered into medical records, and this could be used as a legal document. Advice could be given at antenatal appointments, bringing people's attention to the issues that can arise for parents who are not married, so people are more aware. The executor could be called in as a witness to confirm paternity. There are ways around this if we are creative and clever. In honour of Nicola, Paula and Eleanor and their children, I look forward to hearing how the Minister will take this dilemma forward and hopefully find an answer. When you are widowed young, you lose so much. You lose the partner you love. You lose the life you had built together. You lose the future you had planned. Your children lose their father or sometimes their mother. Their family is never the same again, and their lives will be shaped in many ways by the loss, however young they are when it happened. Being widowed when pregnant is all this and more. The trauma of birthing and grieving at the same time runs deep and lasts a lifetime. I really hope the government will move swiftly to make some changes so that one tiny little bit of this awful journey is made easier for those who have to navigate it. Thank you.
Laurence Turner.
Thank you very much, Madam Deputy Speaker, and may I congratulate and thank the Honourable Member for South Devon on bringing this incredibly important debate to the House and for having the strength to share her experience. And I think she's shone a light on a matter which will resonate with people in every constituency across the country. I rise to raise a related matter which has been brought to my attention and the attention of other representatives in Birmingham by one of my constituents, Womi Babaloa. Last year, she and her partner Charlie lost their infant son, Kayode Babaloa Fellows. Her experience of registering Kayode's death was much more difficult than it needed to be. They found themselves sat at the Birmingham Registry Office alongside new parents who were registering their own children's births. And yet they were required to attend 2 separate appointments on the same day to register a birth and to register their son's passing. Womi said this: "I was already feeling the pain of our loss so much, and when we arrived, we had to sit and wait our turn with everyone else, including with parents, with their babies, registering their births. I felt my loss so intensely at that point. It hit me like a ton of bricks. It should be a joyful time for new parents, while obviously for us, it was an awful, traumatic one. I just didn't feel those 2 worlds should have to collide like they did." I would like to pay tribute, Madam Deputy Speaker, also to Councillor Carmel Corrigan, who is a representative in my constituency in Kings Norton North, who last week moved a motion which was carried at Birmingham City Council, which called on the authority to work with the Registry Office to secure an appointed officer of seniority and with experience of supporting families through their grief, so that people who have experienced baby loss do not have to register their baby's death alongside parents who are registering births, and to explore what additional support the registry service and the NHS can provide to parents in that situation. Carmel spoke about the loss of her own son, Aidan Hay, 28 years ago, when she experienced something very similar. And if something can come out of this debate, I hope it is that there is attention on the issues that the Honourable Member for South Devon raised and that situation that faced my constituent. Because if we can prevent a similar ordeal for other bereaved parents, then we will have done some good. So I would like to pay tribute to all those campaigners, and I include the Honourable Member for South Devon, who have been able to take some form of good from the hardest pain and the dearest loss in order to provide some comfort for others. And I ask the Minister, when she responds to this afternoon's debate, if she will look at the good work which has now been undertaken in Birmingham and also assess the case for national guidance and support for registry officers, so that that set of circumstances which faced Womi and Charlie does not happen again.
Minister, Sarah Sack.
Madam Deputy Speaker, I'd like to start by thanking the Honourable Member for South Devon for securing this debate on an important and emotive subject. Let me start by saying how sorry I am for the loss that she's experienced, that her family has suffered, and how much I admire her resilience in coming to this house to share her story today. That takes a huge amount of courage. The circumstances in which she and others have lost co-parents is heartbreaking indeed, and the government is determined to ensure that the justice system is better able to support children and families, in particular mothers who have lost the father of their child. Madam Deputy Speaker, the Honourable Member of South Devon helpfully outlined the current process for registering a parent's name on a birth certificate when that parent has passed away. But I think it's important to set out precisely how this does work. Under Section 55A of the Family Law Act 1986, in situations where a child is born to unmarried parents and the father is deceased prior to birth, a declaration of parentage must be issued by the court in order for paternity to be established. It's right that a fee is attached to this application, but it's also important to point out that there are mechanisms in place to support those who cannot afford the fee. The Help with Fees scheme considers a range of factors, including an applicant's income, their savings, and whether they receive any benefits, so that the fee, in certain circumstances, can be waived. Once a declaration is issued, the birth can then be re-registered to include the father's details, or to put it another way, as we've heard, to fill in that blank space. To recognise the challenges that mothers face when seeking a declaration of parentage, a key intention of the provisions in family proceedings is to make the process as simple as is possible in the most difficult of circumstances, whilst at the same time still ensuring that the court has the means to establish parentage if one parent is deceased and is not, of course, able to convey their views themselves. That process, whilst we have to emphasise simplicity and ease for those going through the toughest of circumstances, is an important one. It's important because the process, in some cases, can bear on significant financial implications for others, such as children from previous relationships. It can bear on issues such as nationality and indeed on other issues that touch on the best interests of the child. So whilst ensuring the process is clear and simple to support bereaved parents, the courts must have a process in place that instills confidence in the details, the important details, that a birth certificate contains. I'd like to thank the Honourable Member for South Devon too for drawing attention... Yes, I'll give way.
Croft.
Thank you. I thank the Honourable Lady for giving way, and I'd like to add my congratulations to the Member for South Devon for securing this incredibly important debate. My question is, I know you've spoken very well on the process involved. If a couple is married when the father dies while the woman is pregnant, it's a relatively simple process to register that person as being the father of the child. It's a much more complicated matter for people where the couple is not married. I would suggest, and I hope that the Minister will agree, that this perhaps is a case where legislation has not kept pace with societal change and the very real reality of how couples now choose to live when they do indeed plan families.
I thank the Honourable Member for her question, and she is right to reflect on the growing number of couples in this country who cohabit and for whom marriage is not something that they have chosen to do. It's right too that in general that the law keeps up to reflect that sort of societal change, and I'm going to come to that in due course to discuss more widely what the government is doing in that space. But I return to the essential point that whilst clarity, simplicity and affordability is important in the registration process, particularly to support bereaved parents, we've got to have a process that instills confidence in what the birth certificate contains. I would like to thank the Honourable Member for South Devon for drawing attention to Widowed and Young's campaign. As she rightly points out, they do some absolutely amazing work, particularly for those younger people who've tragically lost a spouse or life partner. Madam Deputy Speaker, what I can reassure her now is that the government takes this matter incredibly seriously. We are working hard to improve the family justice system for children and families. Widowed and Young advocate for a simplified court process. We know that one aspect that adds to that distress when someone is going through bereavement is delays in the court process, and that can have a significant impact on children and families. We are committed to improving timeliness and reducing the outstanding caseload in the family court. That's why we've set ambitious targets for reducing delays in the years 2024 to 25 and have focused on closing the longest running cases, not least so that can free up court time to deal with precisely the sorts of processes to which she draws attention. To further support those who use the family court, we're also committed to improving digital solutions to support families explore various options for resolving child arrangement disputes early and away from court whenever possible. This, Madam Deputy Speaker, is an area where digital solutions can be brought to bear on the sorts of issues that have been raised today. And the MOJ, the Ministry of Justice, is working on testing and developing various digital innovations which aim to support users in the private family justice system, to help those families find the right information at the right time for them to reach agreements where that is appropriate, and particularly in these sorts of processes and proceedings which are, in the vast majority of cases, entirely non-contentious. I come then to the wider issue of cohabitation reform, because the subject that the Honourable Member for South Devon raises and that others have raised today speaks to the broader issues for cohabiting couples in our society, who under existing law have only limited financial protections compared to those who are married or in a civil partnership. I know a number of colleagues across the House have written to my department about this, and my noble friend Lord Ponsonby was pleased to attend a parliamentary roundtable to discuss it last November. We know that the limited rights and protections available to cohabitants can, of course, affect the most vulnerable in our society, who are often affected at the most difficult stages in life, such as when a partner dies or at the point of separation. And we know, too, that those limited rights and protections disproportionately affect women, including victims of domestic and economic abuse, as well as their children. With the number of cohabiting couples in the UK having more than doubled over the past 30 years, it's important, as others have said, that law reflects the society in which we now live. That indeed is why the government set out in our manifesto a commitment to strengthen the rights and protections available to women in cohabiting couples. And we will be setting out the next steps on this manifesto commitment, how we intend to implement it as soon as possible. Madam Deputy Speaker, the issue raised by the Honourable Member for South Devon today speaks directly to those challenges that sometimes face parents who are unmarried. And I'd like to thank her once again for securing this important debate and pay tribute to her bravery in coming forward to talk about it. I hope that this is the start of a conversation. I hope that she and I can discuss this in more depth very soon, the sorts of changes that might be necessary to better protect people in law, and I look forward to working with her to that end. Let me also, whilst I'm on my feet, pay tribute to the Honourable Member for Birmingham Northfield for the related issue that he raises, and let me extend my personal condolences to the family. They've been through one of the worst things imaginable in my view, and certainly processes of administration, of registration, should not be designed to exacerbate that. It's something that I'm happy, if he will write to me with that particular case, to take away, and look forward to working with him on how we can limit the distress that parents of children who die in childbirth, how that can be addressed and mitigated. But once again, let me thank the Honourable Member for South Devon for raising this important debate, and I look forward to working with her on how we can ameliorate the situation for those for whom she's campaigning.
The question is that this House do now adjourn. As many as are of that opinion say aye. The ayes have it. Order, order.